Meine sehr geehrten Damen und Herren, es ist mir im Namen der Humboldt-Universität als Präsidentin der Universität eine große Ehre, Sie heute Abend zu begrüßen. Lieber Herr Kollege Hengartner, Herr Prorektor Schwarzenegger, sehr geehrte Frau Mittwoch, lieber Christoph Schneider, verehrte Mitglieder der Humboldt-Stiftung, meine sehr geehrten Damen und Herren. Herzlich willkommen an der Humboldt-Universität. Ich freue mich sehr, dass der Saal auch zur heutigen KOSMOS-Lesung wieder so toll gefüllt ist, dass Sie tatsächlich einfach so kontinuierlich kommen über diese Tage und das mit uns durchdenken, was wir im Rahmen der KOSMOS-Lesung auch Ihnen zu bieten haben. Diese Vorlesungsreihe erfährt einen großen Zuspruch und das zeigt auch, wie hoch das Interesse an aktueller Forschung ist. Im Zentrum des heutigen Vortrages von Frau Mittwoch, am Donnerstag vorgetragen, also im Mittelpunkt dessen stehen die rechtlichen Rahmenbedingungen bei der Entwicklung einer nachhaltigen Gesellschaft. Wenn wir uns das Dreiecksverhältnis von Bevölkerung, Wirtschaft und Politik anschauen, war in den vergangenen Jahrzehnten häufig die Wirtschaft der wesentliche Treiber von Innovationen durch Geschäftsideen. Die Bevölkerung kann durch Nachfrage oder Ablehnung Entwicklung beschleunigen oder behindern. Die Politik kann über die Gesetzgebung Anreize setzen und Verbote regulieren und aussprechen. Im Hinblick auf mehr Nachhaltigkeit im Wirtschaftsleben ist zweifelsfrei die Politik gefordert und Anne-Christin Mittwoch wird uns heute aufzeigen, wie vielleicht eine solche Rahmensetzung aussehen könnte. Der große Zuspruch und die Resonanz der KOSMOS-Veranstaltungsreihe zeigt auch, dass die Idee einer Neuauflage, einer Neuinterpretation dessen, was Alexander von Humboldt in seinen berühmten Vorlesungen vermittelt hat, an ein großes Publikum richtig und gut war. Und für diese Idee und den Einsatz bei der Umsetzung möchte ich Ihnen, lieber Herr Schneider, noch einmal ganz herzlich danken und zugleich das Podium an Sie weitergeben und Ihnen einfach den Platz räumen. Bitte sehr.
Magnifizenzen, Respektabilitäten, ladies and gentlemen, dear colleagues, I am switching to English immediately because tonight's KOSMOS lecture is also part of the KOSMOS conference that we are having at the moment at Humboldt-University, has started last night and will go until tomorrow evening, where we then end with a great public debate. And this conference is international and in English. And so our today's evening also is in English. So wir werden also heute den Abend in Englisch weitermachen, weil diese KOSMOS-Vorlesung gleichzeitig Teil unserer KOSMOS-Konferenz ist, die internationale Gäste nach Berlin gelockt hat, aus vielen verschiedenen Ländern. Ladies and gentlemen, those who have followed the KOSMOS lectures over the last month, I think today is the 7th or the 8th in the series, they know that when I'm starting my moderation and I introduce the speaker of the evening, that usually I have a quote of Alexander von Humboldt to share with you, both in German and English. And I was searching quite a while for a good quote, and I just don't take any quote that you easily find in the internet. Usually I'm going through a couple of books and I look for something that really fits to the topic. And then sometime this afternoon I gave up. Alexander von Humboldt didn't talk about law, about how to bring his systematic thinking into a legal aspects, bring it into some governance. That was, at the time when he was doing his work, this was not a focus. So it's really great that with Anne-Christin Mittwoch, we have a speaker tonight who is taking it beyond. Because this was actually the idea of the KOSMOS lecture. We were saying, okay, let's relate to Alexander von Humboldt, but then let's have a look forward. What's on stage now? What are the things that we have to discuss to make the sustainability transformation happen now in the 21st century? And if it's not about sustainability, because not all of our talks are on this issue, what are the research questions in specific fields that somehow relate to Alexander von Humboldt and then go forward into the 21st century? And in this respect, I think Anne-Christin Mittwoch's talk is really at the heart of Alexander von Humboldt's heritage, because she's taking the systematic view of the world that Alexander von Humboldt has somehow introduced and that we are today interpreting as sustainability sciences, and brings it into the sphere of law, of legal aspects. Okay, so we now know why she's here. And I would shortly introduce her. Anne-Christin Mittwoch studied law at the university in Passau in Bavaria. And she had special language training in English and Spanish, which made her an international scholar. She started her professional career with work in Munich and in Madrid. And then from 2008 to 2013, she was a researcher at the Chair of Civil Law, German, European and International Private and Commercial Law at the Humboldt-Universität zu Berlin. In German language, Professur für bürgerliches Recht, deutsches, europäisches und internationales Privat- und Wirtschaftsrecht. And I think it's a great pleasure, Herr Grundmann, that we have you today in the audience. Thank you for joining us. And then 2013, she finished her PhD, became Doctor of Law at the Faculty of Law here at Humboldt-Universität zu Berlin with highest distinction, which is in Germany summa cum laude, and with her work on harmonization and European private law, method, implications and implementations. Anne-Christin Mittwoch then worked as a postdoc at the Chair of Civil Law, International, Commercial and Corporate Law at the University of Bremen, which is Lehrstuhl für bürgerliches Recht, internationales Handels- und Gesellschaftsrecht. This is really new for me to bring this law language into English. So I'm learning a lot here. Yeah. So and in 2014, she joined the Institute für Handels- und Wirtschaftsrecht, the Institute for Commercial and Economic Law at Philipps-Universität in Marburg, where at the moment she's working as a postdoc researcher at the level of a professor or associate professor. It's great that you've been joining us tonight. We are looking forward to your perspective on sustainability science, and you're really adding a new flavor to the whole discussion, and we really look forward to this. So Anne-Christin Mittwoch, the floor is yours.
Thank you very much, Mr. Schneider, for this kind introduction. Dear Mr. Schneider, dear Mrs. President, dear ladies and gentlemen, I would like to thank you very much for inviting me to present here tonight. It is a special honor and pleasure for me, not only because today's KOSMOS lecture is also part of the KOSMOS conference on navigating the sustainability transformation, but also because it is not self-evident that the legal perspective can and should contribute to the discussion about sustainable development. Almost further away seems the connection to Alexander von Humboldt, the natural scientist and geographer whose memory the KOSMOS lectures are dedicated to. It was not Alexander, but his brother Wilhelm, who, apart from philosophy and history, devoted himself to law in his study. However, Alexander is today perceived as the more interesting, even dazzling figure. But what does jurisprudence have to do with all this? Why is it maybe attractive, but definitely necessary to have a connection between the natural sciences and the legal sciences in order to tackle the current problems of our time with regards to sustainability, climate change, and the planetary boundaries? We can start answering the question with a quote from Alexander von Humboldt himself that maybe describes his work and the foundations and premises of it as a whole. Everything is interaction. Alles ist in Wechselwirkung. Alexander von Humboldt writes into his travel diary in August 1803, while he is traveling the Valley of Mexico. And although he might not have thought particularly about law that day, he constantly teaches us that it is not the accumulation of knowledge that is necessary to tackle the problems of humanity, but thinking in context. And for today's topic, context and interactions, especially between the various disciplines, are pivotal. They are fundamental for sustainability, which, due to its ecological, economic, and social dimension, is interdisciplinary. Nevertheless, the contribution of the legal sciences seems comparatively small in that respect. Apart from environmental law, which is a subdiscipline of public law, and where contributions to the sustainability debate are rather frequent, we lack contributions, particularly in the field of business and finance. Business law or commercial law, corporate law, is a field of private law and thus deals with the relationships among individuals. That means either natural persons or corporations, rather than their relationship to the state, which is rather a subordinate one and therefore connected to public law. One of the main principles of private law is the principle of private autonomy, meaning that individuals are free to negotiate contracts with each other and to conclude contracts without any state intervention being required. This makes it particularly difficult to impose duties on market participants with regards to the concept of sustainability when we use the instrument of private law. It is also argued that it is not the task of legal scholars to make political decisions. And when we explore how the law can be used in order to foster corporate sustainable behavior and discipline unsustainable corporate behavior, we act partly politically because the premise of our work is the assumption that the transformation to sustainable business and finance is needed in order to succeed with our transformation to sustainable society. And this is precisely the challenge that we want to face this evening. In corporate law, it's particularly important to deal with the concept of sustainability. It has not always been like that. Alexander von Humboldt would hardly have been able to anticipate the impact that transnational companies, global supply chains, and internationally connected capital markets have on today's economy and business and finance. Born in the same year James Watt invented the steam engine, Humboldt just experienced the beginning of the Industrial Revolution, which took part to a large extent within the context of the nation state, which is a much smaller context compared to our global economy that we have today. Environmental protection or social security for the workforce did not play a significant role in that time. Technical progress was the main driving force behind the Industrial Revolution and the economic development at that time. And it has to be stressed that Humboldt believed in progress throughout his life. Of course, he was already pointing out the damage that caused by human activity. And he even stated that man raped nature and disrupted its order. Nevertheless, he was convinced that the free movement of goods promoted intellectual exchange between countries and cultures. And he even assumed that man had the right to intervene in nature. However, Humboldt could have probably not imagined the extent to which market participants are doing this today, intervening in nature. The contradiction between the intervention in nature and its preservation is much greater today than it was at Humboldt's time. Business and finance have such a serious influence on the economic, ecological, and social dimension of sustainability that our quote from Humboldt, "Everything is interaction," has a new and somewhat less positive meaning. In order to showcase the relevance of the law of business and finance for the implementation of sustainability, I would like to present one example for each of its dimensions. Thus, we will take a closer look at the interactions Humboldt observed so well, but we will do so with special focus to transnational corporations that dominate the business and finance realm today. We're going to start with the economic dimension of sustainability. We look back a good 10 years ago and remember the developments that triggered the financial crisis of 2007-2008, finally leading to a crisis of the world economy. The decisive factor here is the interaction between various events. Even though the causes of the financial crisis are still subject of controversial debate, it is certain that this chain events ultimately lead or had dramatic consequences. The subprime crisis led to the banking crisis, that in turn led to the crisis of the financial markets, that gave rise to a crisis of the world economy. And thus, the financial market crisis has demonstrated impressively on a global level that everything is indeed an interaction, and therefore a suitable framework is needed for today's business transactions, as well as for the equally networked global capital markets. And this regulatory framework was and is set by law. Legal rules therefore play an important and decisive role when it comes to shaping business and finance, and thus our economic system, and making it operational in practice. The financial crisis rightfully questioned the legal framework that was valid at that time, but it did more. It showed that legal frameworks can be changed. As a reaction to the financial crisis, lawmakers of different jurisdictions reacted quickly and changed individual norms. It remains, of course, questionable to what extent adjustments that have already been made are sufficient, or if further transformations are necessary in order to affect not only details, but also the basis of the legal framework of business and finance. Our second example relates to the ecological aspect of sustainability. Interactions between entrepreneurial activities and the ecological dimension of sustainability exist in various forms. On the one hand, the transnational activities of big companies require long supply and production chains. These supply and production chains result in long transport routes, which allow for cost savings on part of the companies, but which result in greater environmental damages in the form of emissions. In addition to rising emissions, the global increase in transport infrastructure also leads to the destruction of natural landscapes because the logistic infrastructure has to be provided. The reduced costs to the advantage of businesses are therefore in clear contrast to the increased costs to the disadvantage of the environment. However, the latter do not have an impact on the corporate balance sheet. They are mere so-called externalities, meaning they are costs that arise during the production process, but which are not paid for by the polluter and which are therefore not taken into account by market prices. Alexander von Humboldt pointed out the dangers of economic activities for natural ecosystems as early as 1800. During his travels through Venezuela, he described the massive impact of the colonial plantation economy on local ecosystems. Specifically, he observed how the clearing of a large forested area around Lake Valencia led to a severe drop of the water levels of the lake. Consequently, the frequency of the floods around the lake in the deforested area grew and grew, and so the impact of the agriculture, of the local economy, and of the society in the end was rather significant. Such causal chains are often complex and cannot always be easily anticipated. In some cases, economic activities by companies causes damage to such an extent that we speak of environmental disasters. Here we see a picture of the nuclear disaster that occurred with the explosion of the Japanese nuclear power plant Fukushima Daiichi in 2011. Problems for the law in the Fukushima case and related cases are in particularly those of causality and probability, especially with regards to health damage and the environment. In addition, the question arises, to what extent environmental damage can be monetarized? What are the costs of a decimated or even extinct animal or plant species? And in addition, even if we have generally an unlimited liability of the operator, what is to be done in practice if the funds of the operator have been used up? The legal questions that arise in this respect are without a doubt complex. However, what if the law could not only contribute to the management of these tragedies in the aftermath, but also contribute to their prevention? Corporate law forms the framework of corporate behavior and thus has the potential to reduce the effects on the environment through corporate behavior on a daily basis. The possibilities in this respect have not yet been exhausted. And so the list of environmental catastrophes goes on. We remember, for example, the sinking of the Deepwater Horizon oil rig in 2010, causing a severe oil spill in the Gulf of Mexico, or dating further back the accident of Amoco Cadiz at the coast of Brittany in 1978. But the list goes on, and we all know that. Everything is interaction, Alexander von Humboldt observed, and so it is inevitable that economic activity and environmental damage finally leads to an impact on societies or our society as a whole. In particular, trans and multinational companies or groups have an increasing influence on a larger number of individuals, especially their employees, the workforce. Here we see one of the giant sweatshops that produce our fast fashion that we all tend to buy on a daily basis. Companies such as Amazon or Google are in a position to challenge legal, political, and social reaction, even at the international level, due to their economic power. The impact of corporate activity on society is reflected today, particularly in the discussion about the violation of human rights, especially with regards to the employees of the corporations, as well as competition agreements and cartels, or the misleading of consumers and investors. In the economic and legal discussion, we speak about the concept of corporate social responsibility, or CSR. But reality keeps showing us that the legal implementation of corporate social responsibility is still far from being sufficient. This photo shows the collapse of the Rana Plaza building in Bangladesh, mainly used for textile production in April 2013, with over 1,100 deaths and 2,500 injuries. Although cracks had been discovered the day before and the police had closed the building down, the factory operators forced around 3,000 textile workers to start their work and enter the building. Rana Plaza received international media attention, and it reminded the world how hazardous working conditions can be at the bottom of global supply chains. Among the retailers that sourced from Rana Plaza was Primark, an Irish fast fashion company. Prior to the accident, Primark had audited Rana Plaza twice, but the audit did not include a structural survey. This example highlights that if we leave the responsibility for global supply chains to private governance, and that means the companies that sit on the head of the supply chains, then we will have no legal enforcement, and the promotion of environmental or social concerns will be doubtful. The three examples of current tragedies and challenges for the global economy, environment, and society show clearly that legal rules are needed in order to create an appropriate framework for the global transition to sustainability. All dimensions of sustainability are connected to existing legal rules and standards, but they are obviously not enough to tackle our current problems. There are various reasons for this. One of the outstanding reasons is our advanced globalization. Law in the shape of legal rules is traditionally connected and created by the state. But society's current problems are not limited to one state or another. Everything is an interaction. We realize now more than ever that this key message Alexander von Humboldt offers us applies to more than just ecosystems. It applies to our global economy, environment, and society. national legislators are severely overstrained with the monumental task of creating an appropriate framework in that respect. As German or French law is not applicable in China or Bangladesh, where the companies located at the bottom of the supply chains operate, severe governance gaps arise, especially if different companies from different jurisdictions interact with each other. And in that respect, we don't have just a problem with regards to regulation, but also to litigation. But how to incorporate sustainability into regulation? We realize that it is essential that our legal system acknowledges the interaction we've just discussed. The law can and has to be used as an instrument to foster sustainable corporate behavior and to discipline or even prevent corporate unsustainable behavior. In fact, this is not only possible, but we have already created legal obligations to act. In 2015, the member states of the United Nations committed themselves to reaching the 17th SDGs, Sustainable Development Goals. These goals and the Paris Agreement that was signed in the same year form the framework of the various regulation activities worldwide and within the EU. And from a legal perspective, these concretizations are quite fundamental, because lawyers have one core problem when it comes to sustainability. We don't know what it is. And we don't ask the question what it is with sufficient clarity. However, lawyers and legal scholars work with definitions on a daily basis, because their work is to try to find out if a real-life situation is in accordance or is not in accordance with a legal rule, and therefore with a definition within the legal rule. If the understanding of sustainability is crucial for law, the question for corporate law is, what do we want from the companies? What concrete corporate behavior is desired to foster sustainability? I think you all agree that this question can hardly be answered uniformly. It seems easier to us, especially after having discussed the three examples, to define what corporate behavior we want to prevent or even penalize. It is not so easy to define what sustainable corporate behavior should look like in concrete terms. But definitions and concrete definitions are needed in order to assess if an act or omission is lawful. Not only judges need to know about that, but also corporate actors like managers and corporate executives. They need clear guidelines for how to act within their everyday business. The concept of sustainability does not seem to offer this clarity at the first glance. And thus it is viewed very critically by lawyers and legal scholars. It is viewed as too vague, too open, and lacking operability to be included into legal provisions and provide clear guidelines for the addressees. I would like to illustrate this by using one example of the German law, Section 87, German Stock Corporation Act, German Aktiengesetz, which deals with the remuneration of managers. So we're talking about the salary of managers, which is quite, I think, vivid in the political decision after the financial crisis. In the first paragraph, we have a provision which is a general provision in regard to the salary. Interesting for us today is the second sentence that says, the remuneration system of listed companies shall be aimed at the company's sustainable development. Reading the provision, one should expect, at least to some extent, a vivid discussion about the term sustainability and about the meaning and how to reach the company's sustainable development. However, this is actually not the case. Instead, the legal discussion on the meaning of the expression sustainable development of the company is dominated by the view that the concept of sustainability is to be equated with the concept of long-termism. Thus, we only understand sustainability in a temporal sense. The terminology of the International Sustainability Strategy that was coined and developed by the United Nations is ignored. And so are the findings and the development of that definition by the legal sciences, which aren't taken into account either. The point here is not to reproduce this discussion in detail, and it is also not my point to advocate for a broader meaning of the term sustainability in that respect, which doesn't make sense. What I would like to show is that the interaction between jurisprudence and sustainability sciences is currently still deficient, if not inexistent. On the one hand, it is not imaginable for legal scholars to link the context of executive remuneration to the concept of sustainability. But on the other hand, the term sustainability has been used within that legal provision, and now it has to be interpreted and applied. The mere use of the word sustainability, excluding its true meaning, does not promote the sustainable development of corporate behavior, but prevent it or hinder it. In this sense, a recognition and examination of the meaning of sustainability in the natural and sustainability sciences is desirable here. Another example can be found with regards to European law. In March 2018, the European Commission published the EU Action Plan on Financing Sustainable Growth. This initiative is to be very welcomed, as it puts the principle of sustainable finance on the plate, and thus it starts to break down silo thinking, linking the sustainability debate to the discipline of finance. In the early stage of regulating sustainable finance, the Commission considers it most urgent to develop a definition of the sustainability principle. This intention is to be welcomed as well, because now you all know the definitions are the key or the keys for us lawyers to operate. However, the current proposal of the Commission falls again short in that respect. The focus in the action plan is almost exclusively on the ecological dimension of sustainability, and it is even narrower. It focuses more or less on climate change. Reference is also made to other environmental aspects, which are exemplified only at a footnote level. The social dimension of sustainability is touched upon only generically, and fundamental rights are not even named once in the action plan. However, this contradicts again the international sustainability strategy, in particular the implementation of the SDGs, which is expressively one of the foundations of the EU Action Plan. It seems as if they have been ignored again this time by the European legislature. But why is it so difficult for legislators to orient themselves towards this concretization of the term sustainability? The answer might lie within the definition itself. Maybe that is the accusation it lacks operability. Again, the United Nations SDGs concretize the UN's understanding of sustainability. It has been criticized at a very early stage that it was not possible to reconcile these objectives, as they have inherent conflicts. And indeed, if we look, for example, at goal number 13, climate change, and we try to reach that, it will be probably hard, or could probably interfere with goal number 8, economic growth, or vice versa. If you want to reach economic growth and we keep doing it with business as usual, burning fossil fuels and coal, then it will be impossible to reach goal number 13. We must admit that it is really hard to achieve the SDGs as a universal package. However, natural sciences and social sciences have found answers to that problem and a way to make the concept of sustainability more operable. The concept of the planetary boundaries you see here was proposed first in 2009 by Johan Rockström and 28 other scientists of the Stockholm Resilience Center. It assumes that there are 9 critical environmental Earth system processes that regulate the Earth's stability. Associated with them are 9 corresponding thresholds that we need to respect and keep within in order to protect humanity against the risks of irreversible or even catastrophic environmental change. According to Rockström's findings, and this is decisive for us, we can today scientifically quantify these thresholds. Those of you who attend the KOSMOS lecture tomorrow will have that explained in more detail by Rockström himself, which I'm looking quite forward to. For our legal perspective today, it is sufficient that if we manage to stay within these thresholds, we create what Rockström calls a safe operating space for humanity. Thus, it is no surprise that Rockström's concept has been picked up by policymakers worldwide, and it has been picked up even by the UN and even once by the European Union. You can argue now that the concept of the planetary boundary focuses again only on the environmental dimension of sustainability. So 3 years after this was first published, it was complemented by the work of social scientist Kate Rayward, who added a social foundation to the model. She combines social boundaries, such as access to water, food, energy, education, and so on, with the planetary boundaries. Within the planetary ceiling and the social foundation, according to Rockström and Raworth, lies a safe and just operating space for humanity. Of course, this model does not create a legal norm that can be used easily to assess what entrepreneurial decisions should look like in individual cases. Nevertheless, this model creates a clear corridor within which the activity of business and finance has to be placed if we want to move it within the safe and just operating space. So how come this model does not yet inform the basis of corporate law? And why is it still so hard to implement this way of thinking and acting within the sector of business and finance? There is one answer to that question, and it regards the fundamental barrier to corporate sustainability that we face today. The reason is that business and finance today is dominated by the theory of shareholder value primacy. The theory, in short, argues that public corporations belong to their shareholders exclusively and they exist for just one purpose, to maximize shareholders' wealth. And shareholder value is measured by the share price, which changes quickly and thus fosters short-term thinking. So if shareholder value thinking is to be put first with regards to the action of businesses, environmental and social interests cannot really gain momentum besides the overall goal of profit-making. There is much to be discussed about the theory of shareholder value primacy. But as a legal scholar, I have to assure you of one decisive aspect. It is just a theory. Shareholder value primacy is not a legal rule, and it is not mandatory, and no corporate manager is obliged by law to put the interests of shareholders' profit-making first. This has been shown by a large international study carried out by Beata Schafel from the University of Oslo, who examined and compared the jurisdictions of EU member states, European company law, but also US company law and different jurisdictions in addition to that. The results of that study has been groundbreaking because it demonstrates that the sustainability transformation of business and science and finance might be easier as we think, with the shareholder value primacy being just a theory and no hard law. But how can change take place? Now I want to show you what the current approaches look like. There are various approaches for promoting sustainability through entrepreneurial activity. And they are not connected or not confined only to German law, national law. The discussion and implementation takes place in a multi-level system. At an international level, we have international law. Then we have the European Union enacting European law, and at the basis we have the nation states. If they are member states, then they have to transform and apply European law, and besides they can enact their own national law. And apart from this horizontal hierarchy or vertical hierarchy, we have a horizontal hierarchy too. We have some players like private actors, for example NGOs, that have gained a lot of momentum during the recent years. And so when we talk about regulation, we have to interpret this meaning broadly in that sense that it is not just national law. I want to showcase now 3 of the approaches we already discussed. The first one is probably the one that is mostly associated or even identified with sustainability in corporate law, CSR, corporate social responsibility. However, a broad regulation of CSR does not exist. In fact, we as legal scholars are again still unsure about its definition, which is again due to the fact that different regulators in different jurisdictions apply different CSR definitions. And the definition of the European Union has changed considerably during the last years. 2001, the EU identified CSR as a concept whereby companies integrate social and environmental concerns in their business operations and in their interactions with their stakeholders on a voluntary basis. And the voluntary basis is decisive. They were free to do so. 10 years later, the Commission changed its definition and now understands CSR as the responsibility of enterprises to for their impacts on society. So the voluntary element is gone now. And that development led to the enactment of the directive or non-financial reporting, which is dubbed in Germany the Csr Directive, but this term is rather misleading. Because what does the Csr Directive do? It does not formulate specific obligations for corporate behavior. Instead, the directive uses the instrument of accounting. It requires large companies of public interest to provide non-financial reporting on environmental, social, and organizational aspects of their business activities. Thus, companies do not have to act in a certain way, but they have to inform the public about how they act with regards to these topics. In Germany, the implementation of this directive has been limited to just implement the minimum that the directive offers. So we could have done more, we didn't do it. According to Section 289C, German Commercial Code, listed companies, large listed companies that employ more than 500 people on average, have to add a non-financial statement to their annual report. In that statement, they must briefly describe the company's business model and address the question how environmental and labor issues, social aspects, respect for human rights, and the fight against corruption are dealt with by the company. The problem in this context is, however, that there are no binding provisions in EU law of how to present that information. And this is decisive, because without a union-wide standard for preparation and presentation of the information, there is a lack of comparability. And this is critical because the directive relies on the market in order to be effective. Besides the market effect the directive envisages, there are no effective instruments of enforcement if the company does not comply with the obligations of the directive. Thus, it becomes clear that CSR is still to a large extent voluntary, and even more important, it follows a clear business case, the so-called business case for CSR or for sustainability. And I would like to showcase this with an advertisement I found on the website of a US counseling company that counsels SMEs on their way to business success. And there it was stated in this advertisement, corporate responsibility can be a big draw for consumers. And we have a figure which is probably not accurate. 55% of consumers are willing to pay more for products from responsibly, socially or environmentally responsible companies. Thus, the business case clearly aligns the goal of profit-making with the goals of being responsible with regards to society or the environment. The prevailing goal, again, is profit-making, which is put first. And that does not mean that the CSR movement is not a step into the right direction. However, it is not much more than business as usual, and therefore it will not solve the pressing questions of our time with regards to sustainability transformation. But we have to differentiate here, and thus I want to introduce a second and more positive example. Not only do we need legal rules in order to discipline unsustainable corporate behavior, but we need to foster sustainable corporate behavior that already exists. And in fact, we increasingly observe the emerging of sustainable companies on the markets. So the second example is more a bottom-up process that is carried out by a new form of companies labeled as social enterprises or profit and purpose companies. These companies play a pivotal role with regards to sustainability transformation. We have, again, different definitions of how to understand them. In the US American literature, we can find that they are companies uniquely committed to simultaneously earning profits for their shareholders and creating social and environmental benefits. And this is decisive because, and this is what is new, they are business in every sense. They are no charity organizations, but they stand in between and they combine both purposes. And for these kind of new companies, we don't have a legal infrastructure yet, or we are just about to create it. The EU has, again, its own definition, a little bit longer here. An operator in the social economy, they say social enterprises are, whose main objective is to have a social impact rather than make a profit for their owners or shareholders. So the definition of what constitutes such a hybrid vary. You see that because it is a bottom-up process, it is probably not that relevant with regards to mainstream economy, and it's probably still very niche. And you are right. However, we don't have only a small startup culture where we can find social enterprises, but we already observed that big companies that act on a global scale have been converted or are organized now as a social enterprise. For example, Etsy or Patagonia that you see here a company that produces outdoor fashion. But of course, as we are in Berlin today, where we have such a big startup culture, we have to stress that they are very active in this respect either. And in Germany, we have, for example, Einhorn GmbH, which is well now known in this country, which was very successful during the last year and which is also organized as a social enterprise. Now, how to regulate social enterprises? In the EU, we have no unique regulation. The EU has published a strategy on how to regulate social enterprises, but at the moment we are still on the discussion level. And we have different action in different member states. Italy, for example, has introduced a unique legal form for these companies, the Società Benefit, which is oriented very much towards the American model of the benefit corporation, which is again a unique legal form. The EU Commission doesn't really favorize or isn't really convinced of this method of using a legal form. It relies more on the concept of certification, meaning that we're granting social enterprises or sustainable companies a certificate to make them more visible on the market. However, we don't have a unique certification on an EU level already. What we have is different certifications in different member states. In Germany, we have the FINEO Wirkt label, which doesn't play the bigger role here because it is only available for charity sector. In the UK, we have two competing markets, social enterprise mark and badge. In France, we have the Agrément Entreprise Solidaire d'Utilité Sociale, and we have the certified B Corporation, which is an American label, but is also available within the European Union. So there's no doubt that the movement of social enterprise is interesting and promising. However, it has to be emphasized that social enterprises are at the moment not obliged to act sustainably. So at the time that we formulate a definition and a legal infrastructure, it has to be kept in mind that we have to apply again the holistic structure of sustainability, not only the social dimension. And with today's last example, we want to come back to the financial sector. Finance shapes the environmental and social performance of the economy to a large extent. On the one hand, it does so by funding companies of the real economy, of the productive economy. But on the other hand, it does so by gathering significant corporate actors in their own rights, like pension funds, insurance companies, and of course, banks. Thus, it is safe to say that the financial sector today not only serves the real economy, but it has become an important part of it, and sometimes it even dominates it. And structural features of the financial system suggest that there are indeed major factors behind corporate unsustainability, as they tend to focus on short-term profits and not necessarily on long-term sustainability considerations, such as climate change. However, we have to take into account here that we, again, have already visible positive impacts. Like the founders of social enterprises, not all investors are disinterested in the concerns raised by the sustainability discussions. A growing number of green investors are looking to increase their climate-related investments, or they look for socially responsible or ethical investments, impact investment. We have different concepts at the moment. And again, as far as the definition is concerned, as a legal scholar, I'm bombarding you with definitions tonight. We, at the moment, describe sustainable finance as investing through responsible and sustainable or effect-orientated investments with the intention of achieving not only financial returns, but also positive social or environmental impacts through the investment. The EU Action Plan on Financing Sustainable Growth intends to pick up on this movement and to change the problem that we have still with our definitions that vary and the different concepts. The main goals of the action plan are: the EU wants to reorient capital flows towards sustainable investments in order to achieve sustainable growth, to manage financial risks stemming from environmental and social problems, and foster transparency and long-termism in economic activity. We have already discussed one point of criticism here. We have seen that the focus of the action plan is too narrow regarding the definition of sustainability, which is rather defined as ecological sustainability. We also recognize from the first goal of the action plan, and even already from its title, that even if sustainability is important, economic growth is still the main goal of the Commission. And this is partly problematic. An understanding of sustainability that is subordinate to the concept of economic growth is not exactly in line with the UN definition of sustainability. It is again in line with the so-called business case of sustainability. Because the growth paradigm of the economy is not touched upon, the corporate law-related shareholder value theory is not touched upon either. Instead, by pursuing the business case for sustainability, the Commission aligns the goals of sustainable performance and financial performance of a company. This does not really lead to a transformation, as the question of acting sustainably is still subordinate to the question of making profit. Correspondingly, the instruments of the action plan are mostly information duties and nudging, no enforcement rights. However, it is still a plan, and the initiative itself is necessary and to be welcomed. So there will and there have to be discussions about how we want to shape the system of business and finance within Europe. And for this discussion, it is pivotal that we act interdisciplinary. As everything is interaction, we too have to interact in order to think out of the boxes of our own disciplines and to find solutions that are effective on our way towards a sustainable business and finance within the planetary boundaries. In the end, we've come to see that the legal approaches with regards to sustainability are in fact very young. Most of them are just discussions at the moment, and the legal implementation of their results is complex. We have seen that the shareholder value principle that continues to dominate business and finance is currently being questioned more than ever, and other stakeholders' interests, like the workforce, like the environment, and so on, are taken into account. The EU has introduced in discussions and partly already measures with regards to corporate sustainability to the regulation of social enterprises and sustainable finance. And in that respect, more regulation will and has to follow. We have seen that business law, or more specifically company law, is particularly suitable for the task of fostering sustainability in business and finance, because it addresses the company as the main actor of transnational and global markets. In addition, company law shapes the internal structure of businesses, its internal and external governance, and thus it shapes our understanding of the nature of the company itself and its relation to society. Maybe it takes more courage. Maybe it takes more courage, like Alexander von Humboldt had it, to trust that corporate law works without the shareholder value primacy as its dominant paradigm, especially since it is only a theory and not legally binding. I would like to conclude now with a question to Humboldt that you are very welcome to discuss with me afterwards. Alexander von Humboldt, you believe in progress and you support the free movement of goods because it promotes intellectual exchange between people of different countries and cultures. To this end, you also support people's right to intervene in nature. Against the background of your central assumption that everything is interaction, what are your suggestions for the right balance between intervention and preservation? What role does the instrument of legal regulation play in that respect? And what should our next steps be when we try to implement legal rules that shape the behavior of corporations and their relationship to society and the environment? Thank you.
Thank you very much for this bold statement. Please stay on stage because, as you were saying, we got to discuss it. And that's also part of the KOSMOS lecture format that we are having here now for all of this year, that other than in a classical lecture where students just leave the room after the professor has finished, here we invite to discuss at least for a couple of minutes and some questions with the speaker. So I open the debate, and if you are having the microphone, please stand up, shortly say who you are, and try to keep your questions short. David, there is someone here in the middle.
Hello, thanks very much. I'm Johannes Young, academic assistant and PhD candidate with Andreas Engert at the Free University. So today's very hot, so I'm sweating a lot, but I'm also sweating because your talk was very exciting. So thank you very much, Dr. Mittwoch. And you introduced Patagonia and you introduced the Italian corporate form, the new one for social or benefit corporations. But one might say that is like the Paris Agreement of company law. It is good, but it's not quite good enough because it's voluntary. So we do not touch the paradigm of traditional corporations, the first sector. We just say, okay, if you already decided to be sustainable, then we will promote you. But we do not touch the paradigm of corporations. And so Colin Meyer in Oxford has written a new book. It's called Prosperity, and it's excellent. And what he says is that Milton Friedman is dead, and let's not say, long live Milton Friedman. Let's say we need to change the paradigm of the corporation, the traditional corporation as well. And what we need to say is that we have a wrong look at the relationship between purpose and profit. So we need to say profit is a by-result of purpose, and purpose is not the by-result of profit. And do you think we need to change, so the question is, do you think we need to change the Gesellschaft as such and not only promote social corporations?
I think I noticed that the benefit corporation has come quite under fire recently, which is justified. I think this question can't be answered uniformly because it depends on each jurisdiction. As I'm a German legal scholar, I think it's safe to say that with German law, we have our pluralistic approach that is, in my view, it doesn't have to be changed that much. We just have to be conscious of how it was originally meant. I think the principle that the German corporate law already encloses are a good idea in order to foster corporate sustainability. But I think they fall short because the discussion now is very influenced by the US-American approach on shareholder value primacy. And so the whole debate about corporate governance has become very narrowed in the last years. So I think it's safe to say that with regards to German law. But of course, in other jurisdictions, you have to do it otherwise. The main factor, I think, is, yeah, we should change it, but we don't have to change the legal rules that much, as the corporate or the shareholder value primacy is not a legal binding rule anyway. So change is already there, maybe, but it has to be interpreted as such.
We have a second question here in the middle row.
My name is Jan-Erik Schirmer. I work just across the street. I'm also a legal scholar. I'm a postdoc at Humboldt. And thank you, Anna, for this really inspiring talk. I could listen to you all night, you know that, but that was really inspiring. Thank you. I have just one short question. My question is, we talk about how law should change according to sustainability. And when you talk about that change, are you talking about change through regulation, through new laws, or are you talking about change through, let's say, courts and court decision, or even legal scholars? Because I actually have troubles, and I'm still trying to figure out how that should work, how judges should be able to actually make decisions according to sustainability. You talked about this framework and the planetary boundaries. How should a judge actually make a decision according to planetary boundaries? How is she able to do that?
Thanks, Jan, for this question, which is indeed crucial and necessary. I think, again, and this was what I'm saying, that change isn't needed that much. We have to apply the law as it is. And I think with German company law, and I'm speaking of company law in that respect, we can really operate to pave the way towards sustainable corporate behavior. In Germany and in other legal jurisdictions, we have general clauses and we have terms that are open or vague, and we operate with them on a daily basis. So I think it is not out of this world that we should include another one like sustainability, which has already been well defined and developed with the concept I just explained. So I think it is possible to do that, and judges, I think, can and should do it, because I mean judges have also to consider the European law on a daily basis, which they are probably not capable of all the time, but they are doing this. And I think this is a process that has to be started and that will evolve, and I think we can do it. Maybe some changes are needed, but these are minor ones, and maybe afterwards in the longer discussions we can go through them. But I think it is not needed that much, like acting like changing the wording of the core legal provision of company law. I think this is not definitely necessary.
We have another question in the very back there. If you please stand up, shortly say your name. Thank you.
Yes, thank you very much. My name is Hannah Birkenkötter. I'm also a fellow lawyer, although from a neighboring discipline in the sense that I'm not a private lawyer, I'm a public lawyer, I'm a public international law scholar. And my question relates actually to that. So you were talking about private law, about corporate law mainly. As a public international lawyer, for me, when I hear the words transnational corporations, sustainability, CSR, how to make that binding, what comes to mind is a human rights initiative. There are negotiations going on, have been stalled for quite a while on a business and human rights treaty. So that would be regulatory standards, but coming from quite a different angle. So my question to you is twofold. One is, so you just said corporate law in and of itself does not necessarily need to change much, but what about prohibitions? What about the real, sort of like the public law aspect of where you prohibit certain behavior for companies? That wouldn't necessarily be corporate law per se regulating that. That would probably come from a different legal field. But what are your thoughts on that? And if that is an aspect, if that is a factor, don't we as a discipline, as a legal discipline, not only need interdisciplinary research with social sciences, but also intradisciplinary research where public lawyers talk more to private lawyers to understand where we're all coming from? Because I believe the angles that we take are sometimes quite different. Thank you.
Yeah, thank you very much. We definitely need more interdisciplinary work. Definitely public lawyers and private lawyers have to work together. And I think it is a good thing to have public norms and prohibitions and everything that you were suggesting. However, I think this is not enough, as it does not touch on the structure and the nature of a corporation itself. And I think that if you want to change something within the corporation, then you could possibly do this, because it is not that as if we never had this in German law. We had until 1965, we had a provision in German law that the company, the corporation, should work for the common good. So this was the purpose, the expressively stated purpose of corporations. It was not the shareholder value. The Aktiengesetz of that time didn't say anything about shareholder value, but it said that the corporation had to work for the common good. And there is a discussion if we should put something like that into the Aktiengesetz again. And it would indeed have a signaling effect. However, again, it had to be interpreted and applied and so on and so on. So yeah, this could be one instrument. But I think sustainability of corporations, business and finance is a jigsaw puzzle. So we have to work together, not only different disciplines, but also within a discipline. And these are all important steps to do. Yeah.
We have 3 more questions and then we close down the debate. The first one is over there.
Yeah, thank you very much for your talk. My name is Sigrid Rösner. I'm a geographer from the Geo Research Center in Potsdam. I'm not from the legal field at all. However, I would like to come back to your question about interaction, and because you have often mentioned now the German law, corporate law, and I'm wondering, as an outsider who's just reading the news, to what extent does the German corporate law still matters? Because what we observe is a huge globalization, which has, of course, the most severe effect, as you have shown very impressively in your talk, in places which are not so economically developed, which are dependent and vulnerable. And I'm wondering to what extent, actually, this can be tackled predominantly from a legal perspective, because that's also what I'm observing in our society, that a lot of critical points where ethic is requested also on, oh, let's move it to the legal people, let them decide. Yeah. And I find that a little bit, I don't want to say frightening, but I'm wondering at this point, so how do we get back to this, what you described from the corporate law from 1965? Do you see chances, or is the train already gone?
Yeah, thanks for that question. I mean, it's not that obvious for me coming from a legal perspective, but it has to be said that, as I already tried to explain, even though our problems happen on a global scale, we are, as legal scholars, still tied a lot to this nation state, to the national legislatures. So we have to deal with German law. We cannot just ignore it. Although the problems, of course, are further beyond They happen beyond nation states. But if we go a step further, it is safe to say that it is, when I talk about German law, it is not just German law, but it is with regards to corporate law in that respect, the pluralistic system. So we can group different jurisdictions all over the world together. And we can say that the Anglo-American system follows the shareholder value primacy more than the pluralistic German system, which is more in accordance with systems in company law of the Nordic states or the Netherlands. So maybe German law is not really leading in the field of paving the way to corporate sustainability. But the pluralistic system we or the Netherlands or the Nordic states have is indeed an alternative to the shareholder value-oriented systems. So we have to talk about it, indeed. Maybe not under the German way, but with the pluralistic aspect.
Now we have Thorsten Meyreis here with the next question, and it's the second last question.
Yeah, Thorsten Meyreis, theological ethicist. Thank you for your talk. As an ethicist, I really, really liked it. The question arose for me that in international law, as a dilettante, as far as I know, the principle of sustainability doesn't even count as a legal principle. It's rather obiter dictum than ratio decidendi. And there are attempts to make it that by Bosselmann or Capra and Mattei and so on. But those are seen by the legal scholars as well, beautiful but dreamers. So my question is, what you suggest, how far is that what you wish, and how far is it what the courts will do in fact?
Thank you. Yeah, beautiful but dreamers. I like this phrase because it can always be stated when you deal with sustainability in company law. And of course, when you look at international law, it is relative. That means it's just binding when you subscribe to it. Otherwise, nothing will really happen. And the initiative to create obligations with regards to fundamental rights and so on have not been successful in that respect, that we have created these obligations already. But I think it is a process. What seems now really unthinkable might look different a few years ahead. And so I think it is maybe not out of reach that judges will finally apply these principles, but we have to enact them. And maybe we start, as we are Europeans, we start with the European level, because the EU has a lot of initiatives and discussions. And we can take part, not only as legal scholars, but as scholars from different disciplines. And when we create the obligations there, or when we create them, for example, within the social enterprise movement, which seems niche and not really relevant with regards to mainstream company law, we can see how and that it works. And then we can maybe use the fruits of this process for the mainstream discussion. So even if successes seem small, they are necessary steps on the whole picture.
So this is now your time.
Berthold Kuhn, Freie Universität Berlin. A short question to end with. In your talk, you did not touch upon the question writing the principle of sustainability into the Constitution. There was an ongoing debate earlier this year in the Parliament. What's your point of view on that?
Yeah, thanks. I'm not a constitutional lawyer, but I know the debate, of course. I have discussed this quite a lot with colleagues, and I think my personal view is that it would be good to have it in the Constitution, not as an enforceable right, not as a fundamental right, of course. It would be a goal of the state, more or less. For example, it could also be positioned in the preamble or elsewhere. But I think it would have a signaling effect. The Norwegian Constitution, for example, has it. They have the sustainability principle in the Constitution. In Germany, we have a discussion about where to put it and how to express it. But I think it would be good to do it. Yeah, even if it's not enforceable. I mean, as a fundamental right, this is not the point of discussion, but it would be welcome, in my point of view.
Thank you. Ladies and gentlemen, before I let you off the hook, there's 3, maybe 4 items, very short. The first one is, when you have left this this room here with its kind of unpleasant climate at the moment, you're welcome to join the party downstairs in the Court of Honor, the Ehrenhof of Humboldt-Universität zu Berlin. There'll be the science busters, there is something to drink, and there'll be a party tonight, which is part of the festival week that we are celebrating at the honor of Alexander von Humboldt. The second, for those of you that are participants in the KOSMOS conference, now we have heard so much about Johann Rockström that you should be there tomorrow morning, 9 o'clock, when Johann Rockström joins us in the Reuter Auditorium in Dorotheenstraße 24. He actually just sent me a mail with a link where I should download his slides for tomorrow's talk. So he'll be there, and you are dearly invited as participants of the KOSMOS conference to join at 9 o'clock for Johann Rockström's talk. If you're in Berlin, join us, please. And the third one is that, as always, you know that those that are coming regularly here to the KOSMOS lecture, that outside usually you have this bookmark, which is a bookmark with, on the back side, the information of the specific KOSMOS lecture that we are having. So today it's the bookmark with Anne-Christin Mittwoch's name and title. And I'm using this here because our speakers, they get the whole set in once. You don't have to come all the time. We give it to you, the whole set, that like we do it always. And I use it to advertise next KOSMOS lecture, which will be only in October, when the winter term has started again. On the 24th of October 2019, we have Ulf Bündgen. Sounds very German. He's a German, but he's a geographer at the University of Cambridge now, and he'll be talking about interdisciplinary environmental archives from trees. So it's about dendroecology. It will be in German language, interdisziplinäre Umweltarchive aus Bäumen, something that relates quite clearly to Alexander von Humboldt in terms of his work into biogeography. Now, today, this evening, I have learned really a lot. This was a bold statement. I fully enjoyed your talk. And what I really learned is that here at Humboldt University, we have to make an effort to integrate the Faculty of Law more into the IRI thesis, the Integrated Research Institute of the Transformation of Human Environmental Systems, because there is so much that we can learn from law, and there is so much that we can share together to develop those principles that you have been arguing for so boldly tonight. So thank you very much for your contribution tonight. I think we are really proud here at Humboldt-Universität zu Berlin that you are an alumna of our university.
Thank you very much.
Like always, we are offering a T-shirt, which I will not pull out of the sack, and we are offering a coffee cup. And you know, Alexander von Humboldt, when he had his coffee, what he was saying usually, what coffee is, it's condensed sunlight. So enjoy your coffee with a cup of Humboldt University with drawings from Alexander von Humboldt. And everybody enjoy the evening, have a great time downstairs at the festival, and thank you for being here. Good night.